couple of days. There we go. It's recording. Um, and we will follow up with a separate email containing the link to the recorded video as well as access to my presentation materials. And then lastly, whoops, before I start, sorry about that, I will take questions at the end. So if you have a question throughout the presentation, we're going to try and field those with the little Zoom hand. You can also put questions in the chat, but we're going to try with the little hand. So if time permits, I will answer it there. So here we go. Let's get started. So this presentation will cover the basic who, what, when, where, and how of public records, including the definition of public records, retention obligations, handling public record requests, fees, deadlines, exemptions, and appeals, and so much more. So first, the Public Records Law, which is also called the Open Records Law. Some people refer to it as FOIA, which is actually the Federal Freedom of Information Act and only applies to federal agencies, but people still say FOIA requests and also sometimes refer to it as the Sunshine Law. So the Public Records Law applies to every public body in Oregon, and that includes state agencies, local governments, special districts. It includes public corporations such as OHSU and the Oregon Bar. It applies to Oregon courts. I can hear some background noise, so I don't know if I'll just ask everyone to mute, and Kristen, if you can make everyone mute, that would be great too. Okay. Okay, good. Can people hear me? Yes. Okay. I'm going to keep going, assuming people can hear me, but no one else. So it applies to Oregon courts. It applies to a private body when it is the functional equivalent of a public body. It does not apply, however, to the Oregon legislature, but that's because they have their own public records law in ORS 171. So there are two elements of the public records law in Oregon. There's a retention obligation as well as an inspection element. And I included the statutory sites there, but I just want to note that ORS Chapter 192 was renumbered in 2017. So if you have policies or forms that is older than that, predates 2017, you should double check your citations because they may have been renumbered. Okay, so what is a public record under Oregon law? It essentially has three elements. It's any writing that contains information related to the conduct of the public's business that is prepared, owned, used, or retained by a public body. So we're going to go through each of those elements here. So what is a writing? Well, it means more than just what we think of a writing, paper copies of written text. The statute defines writing as handwriting, typewriting, printing, photographing, and every means of recording, including letters, words, pictures, sounds, or symbols, or combination thereof, and all papers, maps, files, facsimiles, or electronic recordings. So that therefore includes sort of what we typically imagine to be public records, reports, agendas, ordinances, resolutions, etc. It also includes AV materials. It includes communications like emails and text messages. It includes calendar entries. It includes Facebook and other social media posts. And this is kind of a big one, and I'm not going to focus on it too much throughout this presentation because it's a very fact-specific question whether a social media post qualifies as a public record. But the point that I want you to take away here and sort of throughout this presentation is if a writing qualifies as a public record, then it doesn't matter the form of the writing. And so that's why I included that here. So voicemails are kind of unique. They are technically a writing, but they are excluded from the retention requirements. So what is not a public record? What does not qualify as a writing? Well, unrecorded vocal communications do not qualify as a writing. And that may seem obvious, but I think we had to have a court tell us that recently, which I think is really funny. So a conversation you had in the hallway with a coworker about, a land use application or something is not that was unrecorded, that was not part of a public meeting, that didn't make it into any minutes, that's not a public record. Also, duplicates are not public records. So let's move to the second element, which is contains information relating to the conduct of a public's business. And that's kind of hard to um, qualify or to define, right? If it contains information relating to the conduct of the public's business and otherwise qualifies as a public record, then it is a public record. But what does that mean? It sort of means it relates to your work or the work of your city. I assume most people on today are city employees, but if you're a district or some other public employee, then sort of relates to either your work or the work of the public body that you work for. It's, I think, easier to define in terms of what it's not. So it does not include information that is purely personal. Um, so by that, I mean, even if it's on your work computer, and let's say you send an email from your work account and it is purely personal, maybe your personal email isn't working or something, or you lost the login information. If the email is purely personal and contains no information relating to the conduct of the public's business, then it is not a public record, even from your account. But, and here's the note here, if personal is mixed in with public, so by that I mean personal information is mixed in with information relating to the conduct of the public's business, then it's a high bar to redact that. And our advice, the best practice is to keep personal stuff on your personal devices and from your personal email address, and public stuff on public devices and from your public email address. And I understand that doesn't always happen, but that's the best practice. So before I move on to non-substantive, I do want to note that if you have public records, this is sort of a common misconception, and you'll hear me say a few of these throughout this presentation. If you have public records on your personal device, let's say you work on something from your home computer for work, and then that file stays there, it does not open everything else on your personal device to public records requests. It doesn't mean at that point that everything on that is subject to public records requests. It still must contain information relating to the conduct of the public's business in order to qualify. So lastly, it does not include non-substantive, and that's kind of a weird word, substantive. But so what I mean is sort of, it doesn't have any substance. It doesn't really contain information relating to the conduct of the public's business. So if you're late for a meeting and you text your colleague, be there in 5, that's not really a public record because it doesn't contain information relating to the conduct of the public's business. Same with sending a colleague a phone number, for example. So sort of like really stuff that doesn't contain information at all is not a public record. Okay, so the third sort of element of the definition is prepared, owned, used, or retained by a public body. So we're going to go through a couple examples here. So a letter written to the city that is used and retained by the city. Is that a public record? Yes, it is. It qualifies. It's a writing. It contains information about the conduct of the public's business, and it's prepared, owned, used, or retained by a public body. What about a letter that's addressed to the city, but it's meant for another government entity? Let's say a school district. Sometimes people, send letters, they think schools in my city, they send the city a letter that's meant for the school district. The city receives the letter and does not retain it, just forwards it right to the school district and does not retain a copy. Well, that's a public record, but it's not a public record of the city. It was not prepared, owned, used, or retained by the city. It's a school district record, but the city is not obligated to retain or produce it if requested. So the last note here is that the record is the entire record. And by that, I mean, the easiest example is an email thread. So I assume all of our email systems When you reply to an email, include the previous email when you hit reply. That previous email, when threaded with the reply, becomes a part of the reply. Both emails are part of that record of the reply. So if you have a long email thread, you meander to a new subject, and all previous replies are included in that thread, then that's all part of that reply, right? And so if that's requested, then you get everything below it. And you cannot, and I'll talk about this more later, you cannot redact for lack of responsiveness. You have to rely on an exemption in order to withhold or redact records. So that all, even if it's not responsive to the request, if it's all in the record is the entire record and you must produce it. So the moral of the story is keep personal stuff on your personal accounts and start a new thread, especially for sensitive matters. Okay, so all public records must be retained according to the retention schedule. There's a general schedule in the Oregon Administrative Rules, but you likely also have specific schedules that apply to you as well. You must keep one official copy of each record for the applicable retention period. And so there's no obligation to retain duplicates. So I want to talk a little bit about this, give an example. So in a meeting, let's say you're in a meeting with a bunch of employees, it's for work, you distribute meeting agendas. Everyone gets a meeting agenda. So during the meeting, there's a very diligent staff member who, oh, sorry. So that meeting agenda is a public record, but you only have to retain one copy, right? And usually the custodian will go to the one person who generated the meeting agenda, the host of the meeting, whatever. Okay, so during the meeting, you have one diligent staff member taking notes, about follow-up items, action items, and oh, I thought of something else, this made me think of something else I need to do for work. So they're adding handwritten notes on the agenda that relate to their work. That copy of the agenda becomes a new public record. It's no longer a duplicate. You have added information about the conduct of the public's business to that agenda, which then becomes its own separate public record that must be retained. Okay. So now let's sort of tweak those facts. You have another colleague in that meeting, and they're maybe less diligent, and they don't take notes, but they make handwritten doodles on their meeting agenda. Like displayed on the screen. That is not a new public record. Even though they've altered the agenda, the alteration does not contain information relating to the conduct of the public's business, and their doodles don't need to be retained. So this duty extends to elected officials, not just staff. So elected officials are subject to the law. Most elected officials we work with transfer their records to the public body and have the public body sort of handle their obligations for them. That's not strictly necessary. I think it is probably what we recommend, but if the elected wants to, manage their own public records, they can. That does include social media posts and emails to and from home computers, provided they otherwise meet the definition of a public record. So destroying and otherwise tampering with public records is a crime, and I am going to read the definition. A person commits the crime of tampering with public records if, without lawful authority, the person knowingly destroys, mutilates, conceals, removes, makes a false entry in, or falsely alters any public record. So in reading that, I emphasize the word knowingly because I want to draw your attention to it. In order for it to be a crime, it must be knowingly done here. So accidentally losing or misplacing or, I don't want to say tampering with, but like writing over or somehow tampering, otherwise messing with, for lack of a better term, a record is not a crime if it's accidental. There may be public relations consequences, and it's best to do everything possible to avoid, accidentally losing records and accidentally altering them. But if you do, you shouldn't be prosecuted for it if it is truly accidental. So lastly, if documents that are scheduled for destruction are requested, then you may not destroy them until the record request is completed. So let's say you have a record that's retention was up, a couple years ago and you just didn't end up getting it destroyed. And then it's requested and you still have it in your office, but you didn't need to keep it. It was scheduled for destruction. It was supposed to be destroyed years ago. You can't destroy it at that point. You have to produce it in the record request. Okay, so let's talk about records requests now. So every person has the right to inspect any public record unless the record is exempt from public inspection. The identity, motive, residency, citizenship, or need of the person requesting is irrelevant unless a particular exemption permits the public body to consider those facts. So an example of when you can consider the identity and motive of a requester is the personal privacy exemption, and whether it would be an unreasonable invasion of privacy to produce the information requested. And the best example of this is a stalker is requesting their victim's personal information. That you can consider when you're considering exemptions or the request. Okay. So more on requests. So every public body must have a written procedure for making records requests. The procedure should include the name of the person that receives the request, the address of that person and how to get in touch with them, and also the manner of calculating fees. So I'm going to have these little tips throughout. So this is my first tip. And I suggest you make a note. If you're not sure whether you have a written procedure, even if you think you do, I recommend that you double check after we hang up from this call today, because that written procedure is very important, because if you have that, you can essentially force requesters through that procedure. And the reason it's important is because that is what triggers the timelines. So if you have this procedure and someone did not go through the procedure, then the timelines don't start. If you don't have the procedure, you just have, for example, typically your city recorder handles all public records requests, but you don't have that procedure, then the timeline starts even if they email someone else making a public record request. So my advice is confirm that you have that written procedure. It's publicly available. It names the person who receives requests, their contact information, and then the manner of calculating fees. Okay, so another tip. A lot of times attorneys use the public records law as sort of a discovery device. So I recommend that you notify us, your attorneys, if you receive a public record request from another attorney, and that includes a law firm or a paralegal, another public body attorney, and you notify your attorney if you receive a request from an opposing party in litigation. And that one is important, not just because we sort of want to be aware of who's making requests, what the nature of the requests are, and especially what records are going out to them. There is a requirement that an opposing party in litigation notify the public body's attorney if they request records that relate to the proceeding. That's in the public records law itself. So that's why I suggest that you notify your attorney every time. So here's the sort of general overview of the process of processing public records requests. So you receive a written request, you determine whether you are the custodian of the records. You can send a clarification if necessary. The law requires that you acknowledge the public record request within 5 business days after receipt. And we'll talk about these more also. This is just sort of an overview. So then if you are planning to charge fees, you compile and send a fee estimate, which may be sent with the acknowledgement. You consider any fee waiver requests you receive. You gather the records that are responsive to the request. You review those records for both exemptions and also public relations purposes. And by that, I mean, even if something is going out, you may just want to coordinate within your, your public body so that people know that something's going out, especially if it is going to get a lot of attention and maybe affect your public body. And then you complete the response, ideally within 15 business days after receipt of the request. So we're going to talk about these more in detail. So again, written request is required if you have your procedure in place, which I know you're all going to confirm after this presentation is over. The law requires that the request be acknowledged within 5 business days after receipt. What does that mean? Acknowledged means that you confirm that you are the custodian of the requested records, or you inform the requester that you're not the custodian of the records, or you tell the requester that you're uncertain whether you are the custodian of the records. And if you do that, then you have to follow up, which makes sense. In lieu of sending that acknowledgement within 5 business days, you may complete the request. You don't have to do both if you complete the request within 5 business days. And that normally applies to records that are routinely requested. So if it's something that's simple that you have at the ready, you can say, like, here you go, complete the response without sending that acknowledgement. Okay, so requests must generally be completed within 15 business days after receiving the request. So the law actually says that the public body shall complete its response, quote, as soon as practicable and without unreasonable delay, end quote. And 15 days after receipt of the written request is basically presumed to be reasonable. The failure of a public body to respond within the prescribed period, within that 15-day period, is treated as a denial, and therefore it may be appealed, in which case the public body must demonstrate that compliance was not required, which we're going to talk about on the next slide. But before we do that, I have heard some confusion on when a response is due, because it's a little confusing. It's due 10 days. The statute says it's due 10 days after the date the acknowledgement is required, not the date the acknowledgement is provided. And the reason that's important is that you gain no benefit by delaying the acknowledgement. It doesn't matter if you send it the same day you receive it. It's not due 10 days after you send the acknowledgement. It's due 10 days after the deadline to send the acknowledgement. So doesn't matter when within that 5-day period, first 5-day period, you send the acknowledgement. Okay, so let's talk a little bit. Oh, before we get to talking about that, if you cannot complete the request within 15 business days, you must provide a reasonable time estimate for when the request will be completed, and that estimate must be provided within 15 business days. The estimate, however, is also appealable to the DA. And the language in the law is it's appealable if the person believes that the estimated time frame is unreasonably long and will result in undue delay of disclosure. So you want to think carefully about how reasonable your estimate is. Okay, so now we're going to talk about when the deadline is impracticable. So the statute actually includes language for when the deadline, that 15 business day deadline, is impracticable. And it shields, so as I say here, shields the public body from compliance. So those 3 situations that are named in the law are: 1, the necessary staff is unavailable because they're on leave or not scheduled to work. And that basically, the legislative history of that sort of, I don't want to call it an excuse, but reason for not complying with the deadline is basically for school districts, small school districts who don't carry a summer staff. So they are on leave or are not scheduled to work, so they are unavailable. So it's not like Sally normally handles your request and she's out today. That wouldn't qualify. The second is compliance would impede the ability to perform other services. And that means the public body's ability to perform other services. The third is the volume of requests being simultaneously processed makes it impracticable. So you have too many requests or too many large requests all at the same time. Now, the public body carries the burden to demonstrate that one of these exceptions applies. And remember, this is appealable. So you'll be carrying the burden to demonstrate it to the district attorney's office. And these exceptions to the 15-day rule are intended to apply narrowly, either to very small public bodies or in unusual circumstances. Okay, so at any time, the public body may request additional information or seek clarification for the purpose of expediting the request. And the important part to know here is that if you request additional information or seek clarification from the requester, the timeline, that 15-day sort of standard timeline, is paused until the requester responds. So let's say you seek clarification in good faith and the requester doesn't respond to your email seeking clarification for 3 days. Well, you have 3 more days. The 15 business days turns into 18 business days from the date you receive the request. If you seek clarification and the requester does not respond within 60 days, and funnily enough, that's not business days, that's calendar days of the request for clarification, then the public body shall close the request. So if you seek clarification and they never respond within 60 calendar days, then you close the request. The person obviously can submit a new request, but your obligations to respond to the initial request end. Okay, so what does it mean to complete a response? Well, the statute tells us what it means. And each of these may or may not be necessary depending on the situation. So what it means to complete a response includes producing the responsive records or directing the requester where those records are publicly available. And I don't think I have this elsewhere in the presentation, but the more routine records you can post automatically somewhere publicly, I feel like it might feel like more work on the back end, but it creates less work for you on the front end, especially if it's records that are routinely requested. So that's another tip that I don't think made it. But post, ordinances, meeting agendas, all that stuff already so that it is publicly available, so you don't have to field requests for it. Okay, so more what it means to complete a response. If you withhold any records or redact any records, you must inform the requester of the exemption you relied on to withhold them. And so before I move on to 3, I want to talk a little bit about a change in the law that I think is sort of unknown. So in 2017, the public records law changed that to require that when a public body cites to the catch-all statutes, and those are these 2 named here, 192-355 sub 8 for federal laws and 355 sub 9 for state laws, those are the catch-all. The law now requires that whenever the public body cites to those laws, it also must cite to the law that the catch-all incorporates. So that's kind of confusing to explain, so I think it's easiest through examples. So let's take the federal law. The federal catch-all law states that any public records or information, these are exempt from disclosure. Public records or information, the disclosure of which is prohibited by federal law or regulations. And the best example here is HIPAA. So if the public body is a covered entity and HIPAA applies, and you receive a public records request and withhold confidential help information from a response based on HIPAA, then in your response, you must cite both the state law here, 192355 sub 8, that is the catch-all that allows you to use HIPAA, and then you also must cite the relevant HIPAA statute that you relied on. So let's do the same exercise for state. So the state catch-all is these records are exempt from disclosure. Public records are information, the disclosure of which is prohibited or restricted or otherwise made confidential or privileged under Oregon law. And the most common sort of generally applicable example is the attorney-client privilege. So if you get a request and withhold privileged information from the response, you must cite both this catch-all, the state catch-all 355 sub 9, and you must cite the statute for the attorney-client privilege, which is 40.225. And that applies no matter what other law is incorporated through the catch-all. Okay, so back to what is complete. So you must separate exempt and non-exempt material if relevant. These are all and or if it applies in the situation. You must inform the requester that you are not the custodian of the requested record. I think that's the follow-up to if you said you were uncertain in the acknowledgement. You must provide a written statement that the law prohibits you from acknowledging whether any requested record exists. That's very rare, probably won't apply at all to anyone here. And if you exempt information from the response, you must inform the requester of their appeal rights. And my tip here is that I would just use the exact language in the statute. No need to get fancy. Just say the requester may seek review of the city's determination pursuant to, and then those are all the statutes. And it's that language is in 192329, which talks about the response. Okay, so let's move on to fees. So a public body may establish fees reasonably calculated to reimburse it for the actual cost of making records available. And you can include most everything in that fee. So you can include locating, summarizing, compiling, tailoring, reviewing, including the attorney's cost for review, redacting, copying, certifying the documents as true copies, and then sending the records by special methods. In your fee, you likely can also include overhead, such as employee benefits. You don't have to just pass through the hourly rate of the employee, but you can include their costs. You can also include, other overhead. The reason I say likely is because I've heard rumblings for years that people are unhappy with that. And so it may eventually be challenged, but it has not yet been. So what can you not include? Well, you cannot include the attorney's time spent determining the application of the public records law. So essentially educating ourselves on whether an exemption applies. You can't pass that through to the requester. And and our attorneys won't include that if we are doing work for you, reviewing requests. We will segregate that time out. And then you cannot include special methods if they are an ADA accommodation. So you can include sending records by special methods as long as that is not an ADA accommodation. The law says that you cannot charge a fee more than $25 unless the requester is provided prior written notice of the estimated fee and then confirms that they want to proceed. And you may require prepayment of the fee prior to processing the request. Okay, so let's talk a little bit about fee waiver requests. I'm not going to read this whole slide. The custodian of a public record may furnish copies without charge or at a substantially reduced fee if the custodian determines that the waiver or reduction of fees is in the public interest because making the record available primarily benefits the general public. So I list some factors here. You can consider the requester's identity, motive, etc. when you're considering a fee waiver request. And what I want to note here is I'm going to talk later about resources. I'm sure you all know about the Attorney General Manual on public records and public meetings. The manual is extremely helpful here. Those 2 bullet points here are pasted directly from the manual, and when I'm advising on fee waiver requests, I often refer to the manual um, for this. So another sort of practical tip is requesters often throw in a fee waiver request in their public record request and just state without support that the request primarily benefits the general public, or even less helpfully, they say because it's in the public interest. And I want to let you know that you should feel free to ask the requester, especially if they're not pressed, to explain to you, demonstrate somehow that waiving the fees is in the public interest because making the record available primarily benefits the general public. And you can even say, I'm denying your fee waiver request at this point, unless or please follow up to demonstrate how making the record available primarily benefits the general public, and say that you would consider a renewed fee waiver request if they provide that information. Even if making the record available primarily benefits the general public, it meets that requirement, they can demonstrate it, the decision to waive fees is discretionary. And that's why that may is underlined there. So even if they meet this test, you can still deny the fee waiver request, but that denial must be reasonable under the totality of the circumstances. And here are some factors that the public body should consider when they meet the primarily benefits the general public, but you still want to deny the fee waiver request. The character of the public interest in the particular disclosure, the extent to which the fee impedes that public interest, and most helpfully for us, the extent to which a waiver would burden the public body. That's, like I said, the most helpful typically to smaller local governments. But I just want to remind you that this decision is also appealable. So you should consider the totality of the circumstances and how reasonable the denial is when you deny and they have met that public interest test. Okay, let's talk briefly about exemptions. So the public records law is a law of disclosure. So the AG, the district attorney, and the courts will generally err on the side of producing records. That means that exemptions are interpreted narrowly. The presumption is that all records are subject to disclosure unless the public body shows an exemption applies. And generally, a public body may release a record even if an exemption applies. There are some laws that do prohibit the release of certain information. I've listed a couple examples here, and the language of the law should make clear whether the public body may or cannot release the exempt information. And if you have any questions about that or anything else, you should consult your attorney, me, us, because that is also appealable. So very briefly, let's talk about the exemptions. Conditional exemptions are in 192.345, and all of these exemptions have the same specific balancing test. The records are exempt unless the public interest requires disclosure in the particular instance. And here's some examples of conditional exemptions. I'm going to kind of go through fast because we're running low on time here. Unconditional exemptions are in quotes because, and they're in 192.355, but many of those exemptions actually do require balancing competing interests. They are conditional, even though they're in the unconditional exemption section. It's just that the balancing test is not standard like it is in 345. So here's some examples. Internal advisory communications are exempt unless in the particular instance, the public interest in encouraging frank communications clearly outweighs the public interest in disclosure. The extremely personal information exemption exempts records unless the public interest by clear and convincing evidence requires disclosure in the particular instance, etc. So here are some relevant exemptions, and these are the most used, I think, for our clients. And I know this is a lot of information, and I just said we're running out of time, but I am going to read them through. So personnel discipline actions and documents supporting them, records that would reveal security measures or potential weaknesses in security measures, internal advisory communications, extremely, as I said, extremely personal information, public body employee home addresses, home phone numbers, other contact information, information submitted in confidence. These are the catch-alls. When exempt public records are shared with another public body, it does not sort of undo the exemption. The records of a library are exempt. And then lastly, information about a personnel investigation of a public safety employee if the investigation does not result in discipline. And I just want to note that what that means for public safety employees is that their investigations or personnel investigations are protected whether they're disciplined under 192.345 sub 12 or not under 181A 674. All other public employees, their personnel discipline actions are only protected if they were disciplined, and that is also a conditional exemption. So lastly, on this subject of exemptions, the AG's office has a catalog of all of the exemptions, and it's regularly updated. It's searchable. It includes AG opinions that refer to the exemption, and it also includes court cases, and it is an extremely helpful resource that I want to let you know about. I will have a resource page at the end. So this slide is called false exemptions, and by that I mean things that people sort of feel in their hearts are exempt, but they actually aren't. So the first example is draft. And I think part of the confusion here is that FOIA, the Federal Freedom of Information Act, does exempt draft records, but Oregon law does not. So what that means is if you're working on a large written document, a big report to the council or something, 100-page document, and it's requested while it's still in draft form, unless another exemption applies, it must be produced, even in draft form. It drafts, just because the fact that it's a draft and not a final does not mean it's exempt. Another false exemption is signatures. People just sort of feel like their signatures shouldn't be public, but there's no exemption that applies to them. Likewise, community members' home contact information, home address, home phone number. An exemption might apply, but it's not itself exempt. So my tip for handling that, if you receive a request and it's not clearly seeking that person's contact information. So what I mean by that is if a person, let's say a member of the press wants to get in touch with someone who made a public comment at a council meeting, that press member wants the contact information. That's the reason they're making the request. Then I don't suggest redacting it. But otherwise, if that's not what the requester is clearly seeking, then you can consider redacting it and citing that personal privacy exemption. And then if you get any pushback, that exemption only applies when it would be an unreasonable invasion of privacy. The courts have said that just like your home phone number and home address is not. So that exemption doesn't apply unless there's some special circumstance, but you can still rely on it to redact it. And if there's any pushback, then produce it unredacted. Like, don't fight about it because we will lose that fight. Okay, so let's put it all together. I swear I'm winding down here and we will take questions. So let's say there was a request for all emails between Ann and Bob regarding the Fancy Lane application. And here's a record. It's an email from Ann to Bob on the Fancy Lane application, and it says, "Hi, Bob, we finally received the Fancy Lane app yesterday. I'm going to send it to attorney Emily to get her advice on it. BT Dubs, how was Caroline's basketball tournament last weekend? Is she at full capacity since her ankle injury? Anyway, let me know if you'd like to discuss the app. Thanks, Ann." So what can be redacted here? Well, I got some bad news for you because pretty much none of it. So let's take it sort of in order here. The first thing people often think is, I'm going to send it to attorney Emily to get her advice on it. The fact that you're consulting with an attorney is not privileged. So that's going out. I also want to note here a common misconception that just because an attorney is CC'd on a communication does not make it privileged. And the flip side of that is just because an attorney is not CC'd does not make it not privileged. It depends on whether the communication is confidential and made in furtherance of legal advice. That's sort of for another day, but just want to note that here. So then moving back to here and what exemptions apply. So this middle paragraph about Caroline's basketball tournament is A, personal, right? Doesn't relate to the conduct of the public's business. And B, it's not responsive. They want fancy lane app stuff, and it's not that. Well, taking those in order, it's unlikely that the personal information here rises to the level needed to redact for unreasonable invasion of privacy. That might feel weird and sound wrong to you, but it's just not likely that that would qualify. So that's going out. And then what about the fact that it's not responsive? That's not what they asked for. Well, the record is the record. The whole record is the record. You can't redact something just because it isn't responsive. You always need an exemption to redact or withhold if it's in a responsive public record. And that would be true also if, let's say, this email from Anne was in reply to Bob's email, and Bob's email was about a different app, a Drury Lane app. And so that's included at the bottom of this, right? Well, that's the whole record in this reply. So unless an exemption separately applies, that initial email starting the thread on a totally different subject is part of this email and is going out unless an exemption applies. So this is kind of scary, I feel like, for some people, especially this Caroline's basketball tournament. I didn't say she's a minor, but it's kind of implied there. And I did that to prove a point, but I just want to carry this sort of hypo to the end, which is if you did redact that, if you really wanted to redact it and cite the personal privacy exemption and the requester appeals and the DA reviews, I can't guarantee anything, but I think it's pretty unlikely that a DA will actually make you unredact it because it's not public information. But my point is, don't put that in there in the first place. That's what I want you to take away. Plus, I can't guarantee what a DA will do. Okay, I'm really running low on time here. So appeals. The requester may appeal. For local governments, they appeal to the county's district attorney. For elected officials, they must appeal in circuit court. These are the appealable decisions, which were marked throughout the presentation with that red stamp. The DA must issue the decision within 7 days, but very frequently requests extensions of time and is granted extensions of time. My advice is to inform your attorney when you receive a notification that a decision is being appealed, because we can help, even if it's just reviewing your response. It is helpful. So the public body bears the burden of showing that the records are exempt from disclosure. The DA might order the records to be released, in which case the requester wins, or may affirm the public body's decision to deny the request and the public body wins. And then either way, that the losing party may challenge the DA's decision in circuit court. And here's another funny sort of recent addition. If the requester wins in circuit court, so the circuit court orders the public body to produce the records, then the attorney fees are mandatory. And that's one of the reasons that I suggest that you loop your attorney early so we can help and make sure that that won't happen, or do our best to ensure that that doesn't happen. So here is a summary. I'm not going to read it because we're running out of time, and I do want to make sure I can get to questions. My last little tip is, when in doubt, consult your attorney. And then I also have a resource page here, which I will briefly talk about, so that it includes the AG manual, the AG exemption catalog, and then the public record orders are now, many of them are now available online. So the attorney generals have been available for a long time, but the public records advocate compiled, I suppose, all non-Multnomah County DA opinions, and then Multnomah County posts their DA orders by topic and exemption, and those are extremely helpful if you want to see how the DA analyzes the personal privacy exemption or confidential submissions. Those are very, very helpful. These are hyperlinked. You can't see it here, obviously, but when we produce the records to you or the presentation to you, you should be able to get them. Okay, so there's a couple minutes for questions. So people raise your hands. I have to rely on Kristen for her help with this. I did see some.
Emily, can you see the chat?
I can. So can a request be made directly to an elected official or only to the jurisdiction they serve? Now, what I would say here is it depends on A, whether you have a written procedure in place, and B, what that written procedure requires. If the procedure requires that all public records requests be made to the city recorder, for example, then I would include elected officials there. Otherwise, it's kind of a free for all. So I would say, I mean, I guess it would be up to the elected official to decide whether to respond, but otherwise the written procedure governs. Okay. Okay, trade secret. I'm not gonna, and I'm sorry, Dan, I can follow up with you. But for trade secret, what I want to note is that vendors like constantly, vendors, contractors, private businesses working with public entities constantly try and argue that something is a trade secret, and they think everything's a trade secret and it's not. So I'm not going to analyze each of these specifically. I can follow up with you, but probably not. It probably does not qualify as a trade secret, especially if a vendor is pressuring you not to release it. There are obviously some things do, but it's a fight we get in a lot. Okay, are there hands up, Kristen?
I am not seeing any hands.
Okay, great. Well then, unless something comes in the chat like right now, thanks everyone for joining and participating. I hope this was helpful. Oh, I see a chat. Oh, just a thank you. Okay, well, thank you for participating and for joining, and we will follow up with the presentation, the video link. The presentation will include the resources links, and you can follow up if you have any follow-up questions. Like I said, I will follow up on trade secrets, and thanks again. Nice to meet you all. Okay.